Good afternoon. My name is Ken Leon-Guerrero with the Guam Citizens for Public Accountability. And I'm testifying against Bill 256. This bill reminds me in so many ways of everything that is bad that has recently happened to Guam taxpayers as a result of backroom deals that led to GRRP, Guam YTK, and the Lejon tax credit lawsuits against the people of Guam. I have nothing against an egg farm. I think it's a good idea. Just as some people thought a waste energy plant was a good idea back in 2000, just as, the fish processing plant at the port was a good idea back in 2000, and some people thought waste energy was a good idea back in 1986. We are here today to talk about stewardship of public assets and for the benefit of existing and future generations. That's what we're here to talk about with Bill 256. Now, as an aside, I have kind of a little bit of experience with this because some time ago, I was approached by Gita to look at this property to develop some type of business model on it. I was proposing to put in a farm that was going to be raising vegetables and fruits and provide full-time employment for 100 or more people with developmental disabilities. And I was proposing to use the federal recognized offset of this type of program under the National Institute for People with Severe Handicaps, which recognizes that a full-time employed person relieves the government of $1,800 a year or more. And so by employing 100 people or more, I was proposing to use the offset of $186,000 towards the $150,000 minimal rent. And I was denied because the reasoning was that this land is to generate revenue for Chamorro Land Trust to pay for infrastructure and surveying of other land trust properties, and using a offset wasn't going to generate any revenue for Chamorro Land Trust. So, Bill 256 is no different than the bills that led to the creation of GRRP and Guam YTK and what ultimately became the Lejon tax credit situation, in which taxpayers have lost millions of dollars and potentially could lose hundreds of millions of dollars more. After reviewing the documents under the FOIA requests to both Gita and Department of Land Management, I've come to the conclusion that the original underlying lease was dead. So this bill right here is an attempt to codify a bad situation for the taxpayer, much in the same way Bill 433 in the 32nd legislature was an attempt by GRRP to codify the waste energy process, and subsequent efforts by the administration to ram waste energy through this body through Gita. So now we have Gita at the leading edge of GRP, and now we're looking at Gita handling a dead lease, artificially breathing life into it and resurrecting it and creating a fictition that this lease was a going concern. Problem number one. The original lease to Kusam was 50 years. This bill says it was a 50-year lease, but it was not. It was a 10-year lease with 4 10-year extensions contingent on satisfactory performance of the terms and conditions of the lease therein. And one of the conditions was certification by the Director of Agriculture after year 3 that the farm was a viable and going concern. There's no such documentation in any of the files I read. In fact, there is a request from Kusan to extend the certification period because they were having problems. But nowhere in there do I see a report that certifies that that this farm was a going concern eligible for extension of the lease. Much in the same way that the Guam YTK had a 5-year lease subject to approval by this body for 8 5-year extensions. That never happened, and now the taxpayers of Guam are sitting here in the Supreme Court waiting for the approval by the Supreme Court body on a $20 million payout to a group of investors on a piece of property owned by the taxpayers that was never paid for. A project was never completed. No taxes were collected, no investments were made, yet the taxpayers somehow are supposed to pay out $20 million. That's why stewardship of this process is very, very important, to make sure that all good intentions aside, and I was very impressed with Manhita's presentation, but the road to hell is paved with good intentions. We don't know what's going to come down the road. That's why when we go through this bill, go through the existing leases, we have to be concerned. Because here, problem number 2. The original lease died in 1995 for failure to make lease rent payments and failure to get the certification required and failure to make payments to GITA that would require a 10-year extension to be granted. So since that 10-year extension was never granted, there was a failure here among the administration, when I'm talking about the government administration, to execute their processes effectively. In other words, that land should have been returned to the inventory of CLTC at the time, and it wasn't. It was kept out of CLTC under the assumption that GITA had assumed the lease. But the Director of Department of Agriculture, he had the authority to allow assumption of the lease subject to the existing terms and conditions being completed. GITA never completed the terms and conditions of the lease. They never made any lease payments. And one of the terms and conditions is the land must be utilized. It cannot be allowed to go fallow. If it goes fallow, then the land reverts back to Department of Agriculture. GITA, by their own admission, let the land sit fallow for 20 years. They didn't make any payments. Now, the formula on the lease is minimum payment of 2,995 years per acre with a maximum $25,000 offset credit for improvements to the property. So there is still an amount of money that was to be paid to the Department of Agriculture, and since GITA did not make any payments, and in the documentation I received from GITA, they claim in their own documentation that they never made any payments to Department of Agriculture. So in order for a lease to be alive, the terms have to be met, the payments have to be made. And I know this from personal experience. We have a piece of property. The lessee defaulted on the lease. The bank took over the lease. The bank made the payments on the lease to keep the lease alive so they could sell the asset so that they could recover their investment with the prior lessee. GITA did none of those things. GITA made no payments. GITA did not honor or respect any of the terms. Department of Agriculture never extended the lease. So it was in effect a dead lease. Problem number 3. When the loan payment stopped and GITA foreclosed on the property, by law, the land should have reverted back to Department of Agriculture or to CLTC. In order for the Kusan lease to be viable, GITA would have had to make a minimum payment of $150,000 a year under Section 3 of the lease with the Department of Agriculture, or at a minimum, to keep the fiction this lease is alive, they should have required whoever assumed the lease to make all the back payments plus interest money to be forwarded to CLTC. None of that happened. So at best, all GITA had was a legal lien on the property. That's not the same thing as saying that GITA had an active lease that they could sell as an asset. Number 4, the Kusan lease was legally dead by failure of GITA to comply with all the terms of the conditions. First, by allowing the land to go fallow. Second, by not providing an annual report to the Director of Department of Agriculture on the amount of produce produced on the land in compliance with the lease. There was a lease, and in the lease, there was a list of the authorized products to be planted on this farm. The lessee was required to provide an annual report on the quantities of these products produced on the farm. GETA failed to do that. It's also dead because of under Public Law 1518, which created these farms, the Director of Agriculture had the authority to allow transfer of ownership of the ground lease for the purposes of financing improvements, but the law did not give the Director of Agriculture authority to waive any of the terms and conditions or lease payments. So the letter that GETA has from Director of Agriculture authorizing GETA not to make any payments is in direct violation with the law, and therefore, not defendable. There is fictition that this bill is necessary for the financing of an egg farm. I don't deny the fact that they're going to need to finance this. I doubt very seriously the banks and lending institutions are requiring a 50-year lease or a 100-year lease. What you guys don't know about me, I'm born in Iowa, and I come from a farming family, so I have a little bit of knowledge about, just enough to be dangerous, about farming. And typically when relatives of mine have made loans for farming things like milking barns, the average loan has been 10 or 15 years. Because of the wear and tear on the assets, they don't survive longer than 10 or 15 years. So farming barns, milking operations typically get 10 to 15 years of financing. So I don't understand why they aren't able to get financing for $8 million, and over the 24-year lifespan, that's $370,000 a year write-off. I haven't seen what their business model is, but I'm sure that with no land payments and a captive market and selling 100% of their production, they should have been able to afford a 10-year, a 15-year, even a 20-year loan and make those numbers work. Now, the real bad problem with this bill is CLTC will not see 1 penny of income on this property for the next 100 years based on the amount that Manhita has paid so far, and according to the records GETA has for their past collection. And so continuing the extension of a public asset for 100 years with no rent collection will not do anything to further the development of infrastructure or surveying of the rest of the properties under CLTC. Now, the next problem is, unlike the original lease, this bill allows subdivision and rental of the property. And this was the biggest red flag for me, because here we have 50 acres of prime property less than a mile from Anderson Air Force Base front gate and less than a mile from Northwest Field front gate, which is going to be the site of the future Marine base. What possible things could I do with 50 acres of land in that area that would enhance my personal income, especially if I had a 100-year lease? Now, the problem with this is this prevents development of private property in the area for the same purposes, because how could I compete if I'm going to build a warehouse or an office building? How could I compete with a business that has no rent, no property taxes, and no corporate taxes for the next 25 years? How could I possibly build an office building or a warehouse that I could rent and make money competing against this type of an operation? So that's another big red flag, because the goal of GITA is to develop the economy. This lease and that clause specifically will inhibit development of properties anywhere in that area, because there's no way a private developer could compete against a similar project that would be built on that property. And with the authority to subdivide and sublease, that basically limits what can be done on anybody else's property. So this is a failure of processes, and something that this body should work hard at correcting, because here we have valuable public assets that are under the supervision of political appointees who, without public vision or public input, are able to transfer these assets around amongst each other for the benefit of well-connected political supporters. Offering 100 years of free land with no property taxes for 10 years, minimal corporate taxes for 25 years, without legislative oversight or public hearings, was definitely not in the best interest of the residents of Guam or the Chamorro Land Trust. The proposed
I'm going to need you to wrap up shortly here.
Okay, the proposed bill, as written, does nothing to improve the Chamorro Land Trust. It does everything to inhibit economic development in this area and property, and sets up the next Guam YTK. So just based on the amount of information that I learned in this hearing that was not given to me in my FOIA searches, raises more big red flags about how much more information is out there that we don't know about related to these transactions. And I think that this bill should be pulled, more research, because there's a lack of due diligence on the part of GITA. It's even worse than the lack of due diligence they did on GRRP. So I think we need to pull this bill off the table, do more research, or introduce a new lease that takes into current market conditions and current market prices, because valuing this piece of property, 50 acres at $1 million, is a disservice, because there's a piece of property 2 miles from Naval Station that was valued at $8.5 million.
All right, thank you. Please submit your written testimony to the staff.
Okay.
Okay.
Am I permitted to read Darrell's testimony?
No, you can submit a written copy of it, and the panel can read it themselves.
Now, we've been listening for over 2 hours to people supporting this.
Okay, I'll give you 5 minutes then to read what Mr. Taggarty.
Okay. Let me pull it up here. This is Darrell Taggarty's testimony. Mr. Chairman, I oppose Bill 256-34 and urge all committee members not to vote it out. This is a private bill that creates real marketable value for the beneficiary where none existed before, in exchange for hidden benefits for senators who vote in favor of it, and merely theoretical benefit for the rest of us. This bill is a perfect opportunity to list other bills that have passed without clear benefit to the public, which I will do if Bill 256 proceeds out of committee. I am optimistic that you, our current elected policymakers, will do the right thing by killing this bill in committee. The legislature delegated powers to the Department of Agriculture, GITA, and the Chamorro Land Trust to fairly and impartially administer public lands for agricultural purposes. Their procedures were approved. Manhita Farms LLC considered the GITA note profitable as is, with the remaining 24-year term and original conditions attached to the land. Nothing stops Manhita Farms from moving forward with its agribusiness plan. The public and Manhita Farms already can achieve positive benefits spilled out in this bill without passing this bill. However, this private bill proposes to override powers delegated to executive agency employees, boards, and commissions, so 8 senators can get the gift of massive amounts of, 8 senators can gift a massive amount of extra dollars to Manhita Farms. Was this opportunity publicly offered? Is there anyone else out there that would like to negotiate with the government and offer better terms? I don't recall Gita advertising its portfolio to public bids. I don't recall the Chamorro Land Trust putting surveyed properties out for proposals so that anyone and everyone would have a chance at getting subsidized land. This private bill suspends specific terms of the documents attached to this property. The public is left unprotected under current programs to facilitate agriculture and economic use of public lands. Manhita's lawyers can argue that this law is equal to and more recent than any other applicable law and superior to the lease terms. Agriculture, Gita, and the Chamorro Land Trust agents and boards can't assert the public's continuing interest in the face of a law that approves privatization of this property. This private bill is just like the legislative spot rezoning of village land and permanent giveaways of public properties formerly used as public right-of-ways without considering their future value as off-road strand parks for public enjoyment. Let's look further into the highest and best use of this land, a standard which can be applied during government consideration of rezoning, subsidized infrastructure of government funding. This land is a large continuous tract that is zoned agricultural now, but it does not preclude development of a gated community of luxury homes on half-acre lots within a mile of the new gate at Anderson Air Force Base and astride all the future traffic between the new Marine Corps Base and Anderson. It is large enough for a major mall or a gated red light district. So many opportunities other than agriculture can open up when a private bill extends lease terms beyond the remaining 24 years and releases the lessee from the agriculture-only performance conditions. It allows people who are Manhita Farms to legislatively leapfrog other private landowners in the area, including investors in the nearby golf course. In closing, I reiterate my pledge to drag up private bills that have little public purpose if this bill is to proceed. Like Senator Nelson's recent call for federal investigation, I would feel reassured if the U.S. Attorney would examine this and similar historical bills for corrupt government practices and racketeering, since not all factors or procedures that led to this bill are on the table today. Thank you for carefully considering my perspective on this matter. Darrell Taggarty.
Thank you. Thank you very much.